Thank you. Thank you, Suzanne, for that lengthy introduction. I regret that we've exhausted all the time for audience questions. You put your pens and papers down. But it is a great honor for me to be here. I had the opportunity to meet with Suzanne and with Dr. Hamre before we began this event today. And one of the issues we talked about was fake news. And so I feel obligated to correct the record, Suzanne, on just one point. And that is, I regret I am not the longest serving U.S. attorney in history. I think I am the longest serving in this century, which is not all that long so far. But in fact, in my home state of Maryland, there was a U.S. attorney who served for 19 years, and I served for only 12, so I am far from achieving that distinction. But my career in the department does go back so far that I remember when Bill Barr was the Attorney General of the United States. He was actually Deputy Attorney General when I began my job, and then ascended to the Attorney General position thereafter. And we are very grateful and very fortunate to have him back. And I think that is yet another example of a superb appointment that President Trump has made, which I believe does demonstrate a commitment to the rule of law. And I'm grateful to the Center for Strategic and International Studies for giving me the opportunity today to talk about my perspective on the rule of law and some of the things that I think that we're doing to accomplish that. A prosperous and safe society needs to vest some people with the power to govern, the ability to set enforceable rules, to punish violations, and to act on behalf of the people. The question is how that governing power should be exercised and controlled. One of our nation's founders, John Adams, advocated a government of laws, not of men. The goal is for the people who exercise government power to act in accordance with neutral principles and fair processes while respecting individual rights. The idea dates at least to the 4th century BC, when the Greek philosopher Aristotle wrote, "It is more proper that the law should govern than any one of the citizens." Last year, President Trump issued a proclamation explaining that we govern ourselves in accordance with the rule of law rather than the whims of an elite few or the dictates of collective will. Through law, we have ensured liberty. As the President recognized, law provides a framework for freedom. At its best, law reflects moral choices, principled decisions that promote society's best interests and protect citizens' fundamental rights. John MacArthur McGuire described law as a system of wise restraints that make men free. The restraints preserve liberty because they are prescribed in advance and they apply to everyone without regard to rank or status. The rule of law is indispensable to a prosperous and thriving society. It allows businesses to enter into contracts. It gives innovators protection for their discoveries. It keeps people safe from dangerous criminals. And it allows us to resolve our differences peacefully through reason and logic. Justice Anthony Kennedy explained it this way: in a rule of law system, when you apply to a government clerk for a permit and you meet the criteria, you're not asking for a favor. You have a right to the permit, and that clerk has an obligation to give it to you. In many countries, that concept of government officials bound by law to serve the people simply does not exist. Now, a society can achieve the appearance of the rule of law without accomplishing it in fact. In Shakespeare's play, Henry IV, a prince brags about his connections to the devil. He proudly proclaims, "I can summon spirits from the vasty deep." His skeptical friend mockingly replies, "Well, so can I. But the question is, will they come when you call them?" An agreed-upon set of rules is a necessary condition for a system that operates under the rule of law, but it is not a sufficient condition. The rule of law is not just about written precepts. It's not just about the words. It depends on the vigilance and character of the individual men and women who faithfully implement it. The enforcement mechanism is crucial, as James Madison recognized in Federalist 51, because you must first enable the government to control the governed and in the next place, oblige it to control itself. The founders of our nation well understood that challenge. First, they fought a war on their own soil to break free from rule by a foreign monarch. Then they operated for a decade under the Articles of Confederation with a weak central government that proved incapable of fulfilling its obligations. So in 1787, the Constitutional Convention met in Philadelphia to establish the foundational rules for a new form of government. The founders agreed on a written constitution establishing a system that divides government power among the legislative, executive, and judicial branches. The system protects against the concentration of power by allowing each branch to check and balance the others. Sometimes it's a messy system, as we see played out from time to time not far from here on Capitol Hill. The founders recognized that. When Benjamin Franklin was walking home from the Constitutional Convention, a woman named Elizabeth Powell stopped him and asked him what type of government the founders had created. Franklin replied with these words, "A republic, if you can keep it." Some people think that politicians are responsible for keeping the republic, but Franklin spoke to an ordinary citizen, a woman who at the time did not even have the right to vote, but he said it was her responsibility, not his, to keep the republic. The lesson is that a constitutional republic's success depends on people, on citizens conscientiously applying and respecting the rules. And one indicator that we are faithfully enforcing the rule of law is when we accept a result, even though we personally dislike the outcome. We respect it because it's the result of a fair process, an objective analysis of the facts, and a rational application of the predetermined rules. An independent judiciary is a central pillar of our system. Our federal judges, by design, do not defer to the popular will. They do not run for election. They do not answer to the executive branch, nor are they beholden to the legislature. Their duty is to say what the law is, independently and impartially. They take an oath to administer justice without respect to persons and to impartially perform their duties. The judicial branch is independent because we accept its final rulings even when we disagree with them. The judiciary serves as a check on the other branches, not a subordinate. Now, American institutions and the people who compose them often fall short of our ideals. No system is infallible, but at its core, our society fundamentally respects the rule of law, by which we mean a system that is just and is protective of human freedoms. Not all nations share that concept. As we seek to build bridges with foreign adversaries, it's important for us to understand the differing visions that underlay their legal systems. In China, for example, the Supreme Court urged government officials to resist Western-style judicial independence, deriding it as erroneous and mistaken. The Chinese Communist Party sits above the government. In January, a party directive instructed the country's courts to protect the party's political security. Instead of maintaining independence from the executive branch, the Chinese judiciary's duty is to further Communist Party goals. The party controls the appointment of judges and even dictates some of their rulings. Daily practice in the courts is also a study in contrasts. In our courts, the presumption of innocence is perhaps the most important safeguard of individual liberty. When our government makes an allegation of wrongdoing, we need to prove it. We must present evidence that satisfies the rules governing admissibility. We need to call witnesses who remain credible when subjected to vigorous cross-examination. That's one of the reasons why it's important for government officials to refrain from making allegations of wrongdoing when they're not backed by charges that we are prepared to prove in court. In a trial, a defendant gets a right, an opportunity to present his own evidence and present his own witnesses. And that presumption of innocence is overcome only if we prove our case to the unanimous satisfaction of a judge and 12 random citizens. If even one juror is unconvinced, the defendant prevails. Government officials may sincerely believe a defendant is guilty, but their belief is irrelevant. Investigators and prosecutors in America do not get to decree which facts are true. In contrast, the Chinese system effectively presumes guilt when a defendant stands accused of a crime. Moreover, that presumption is all but irrebuttable. Chinese judges receive the government's evidence before trial, without opportunity for comment or cross-examination by the defense. Live testimony is offered only rarely. There's little to no opportunity to impeach witnesses. Prosecutors, as a result, rarely lose. There are also substantial differences in our criminal arrest and detention practices. In the United States, a criminal defendant arrested by police without a warrant has a right to appear before a neutral judge within 48 hours. If police satisfy the judge in advance through a sworn allegation of wrongdoing and obtain a warrant before making the arrest, the defendant still has a right to review by a judge without unnecessary delay. A criminal defendant may be detained in the United States only if there is a judicial finding that there's probable cause to believe that he committed a crime, not simply based upon the assertion of a government official. In addition, federal law still requires release before trial, unless the judge finds by clear and convincing evidence that the defendant would pose a risk of flight or a danger to the community if he were released while awaiting an adjudication at trial. In China, forms of extrajudicial pretrial detention are enshrined in law. Last September, the former president of Interpol, Meng Hongwei, was forcibly detained by his own government without explanation. In China, that's not a violation of the rule of law. That's what the law permits. Meng has reportedly been detained under a new form of custody known as liuzhi, or retention in custody. Under that form of custody, a suspect is held incommunicado at an undisclosed location and denied access to legal counsel and family for as long as 6 months without charges. And in Xinjiang province, Chinese law allows the extrajudicial mass detention of citizens who are ethnic Uyghurs, a minority population native to the province. Today, more than 1 million Uyghurs and other minorities reportedly are detained in internment camps. They're forced to renounce their culture and religion, and they face political re-education. That's today in the modern era. The province's law authorizes the arrest of anyone for violations that include expressing allegiance to Uyghur culture and reading prohibited religious books. Many people have been arrested and detained for long periods of time without charge, trial, or due process. Citizens of countries that operate in that way are subjected to rule through law rather than rule of law. The law does not charge anyone with serving as an independent guarantor of liberties or a check on political influence, as in the American system. Instead, the law is an instrument of state power, a mechanism for rulers to maintain control and to quash dissent. In the absence of a culture that respects the rule of law, written protections are routinely violated and seldom enforced. Victims are bereft of any legal remedy. In those nations, law may be used instrumentally as either a weapon or a shield, not merely against their domestic populations, but also beyond their borders. They direct their transactional approach to the law outward with far-reaching effects. China, for example, appears to detain foreign citizens as a means of retaliating or inflicting political pressure on other countries. In 2014, Canadian authorities arrested a Chinese national named Su Bin at the request of the United States to face serious charges. We sought his extradition for hacking-related offenses and the theft of sensitive military and export control data that was sent to China. In an apparent act of reprisal, Chinese authorities apprehended a Canadian couple who had lived in China for 30 years without incident. They were accused of spying and threatened with execution. The wife ultimately was detained for 6 months before being released on conditions. The husband did not meet with a lawyer for almost a year. He was held for more than 2 years. Meanwhile, Su Bin, the defendant charged in the United States, consented to his transport here, retained a lawyer of his choice, and received all the protections afforded a criminal defendant in our system, including the right to a fair and open trial. In some cases, China, Russia, and other authoritarian nations overtly shield their nationals from the fair administration of justice. For example, they refuse, in some cases, to provide mutual legal assistance in response to justified requests from the United States and other countries for evidence necessary to criminal investigations and prosecutions. As transnational crime increases in scope and complexity, we increasingly face cross-border criminal investigations with defendants, witnesses, and evidence that span the globe. Countries depend heavily on the expeditious international cooperation to build cases and to locate, arrest, and extradite fugitives to hold them to account for their crimes. If we don't cooperate, we'll all be vulnerable to criminal activity by persons operating in other countries. Providing those sort of safe havens for criminals is a violation of the rule of law. Some countries also undermine the law by using extra-legal means to forcibly repatriate fugitives. China sends agents, known as fox hunt teams, to the United States and elsewhere to track down Chinese nationals accused of political or corruption crimes. Those squads enter foreign countries under false pretenses, track down fugitives, and deploy intimidation tactics to try to coerce them to return to China. Inside China, government officials possess authority to impose exit bans, prohibiting some foreigners from leaving the country without judicial approval. They sometimes use bans as a form of coercion to compel the victim's relative or friend suspected of wrongdoing to return to China. One American teenager, a college sophomore enrolled not far from here, is now trapped in China, being used effectively as a hostage in an effort to coerce his father to return to China. China's abuse of foreign visitors as political pawns caused the State Department to issue a travel advisory last month. Now, in the United States, we strive to faithfully and responsibly discharge our responsibilities to assist foreign law enforcement, providing due process, holding criminals accountable, and respecting individual rights. When Chinese citizens who commit crimes in other countries remain in China, China neither extradites them nor holds them accountable there. In contrast, the United States extradites its own citizens, as well as foreign nationals, when the law warrants it. Over the past 5 years, we have extradited 95 Americans. We also cooperate with other countries' requests for mutual legal assistance and for assistance in their investigations and prosecutions. We do so based on a fair-minded assessment of the evidence. Last year, for instance, the United States removed a Chinese fugitive, Xu Chaofan, who allegedly embezzled $485 million from the Bank of China. Combating transnational crime requires foreign partners to act reciprocally, transparently, and in good faith. When a fair-minded assessment of the evidence establishes significant crimes, nations should not shield citizens from the fair administration of justice or otherwise subvert legal process. Some countries also seek to achieve their ends by changing global criminal justice norms. For instance, Russia and China seek to replace the Budapest Convention on Cybercrime. That convention is approved and now in effect by 60 nations, including the United States. It harmonizes national interests and enhances the flow of electronic evidence among nations in order to facilitate the investigation of cyber crimes while balancing civil liberties and privacy interests. Russia rejects the Budapest Convention, complaining that it allows individual owners of data to control it. In its place, Russia seeks to allow a new convention that would enhance the ability of regimes to control communication, limit information sharing between nations, and impede efforts to investigate cybercrime. We reject that effort to undermine the goal of an open internet, governed by the rule of law and protected by international cooperation. I want to emphasize that the people of China, Russia, and other nations that do not share our respect for individual rights are not our enemies. It's good for us to seek common ground with their leaders. President Trump describes our relationship as a new era of competition. He extends an open hand to rival powers that seek to challenge American influence, values, and wealth. We will attempt to build a great partnership with those in other countries, but, the President says, in a manner that always protects our national interest. The rule of law is central to our national interest. While we cannot expect any system to be flawless in execution, the key issue is whether the government establishes fair rules, respects individual rights, and punishes violations. Consider the murder of Jamal Khashoggi. There may be factual disputes about who is responsible for an extrajudicial killing, but our allies must agree on the principle that each culpable person should be held accountable, because a government that operates under the rule of law cannot condone the cold-blooded murder of nonviolent dissidents. Let me conclude with an observation. I'm proud to serve in the Department of Justice with 115,000 colleagues who promote the rule of law, a goal held jointly by our partners in state and local law enforcement. We share a noble calling to pursue justice, a calling enforced by the additional safeguard of an independent judiciary. We work regularly with our law enforcement partners in China, Russia, and other nations to advance our interests, but always with a clear-eyed understanding of our responsibility to serve as vigilant custodians of the rule of law. Our Constitution aspires to secure the blessings of liberty to ourselves and our posterity. In order to sustain it in an interconnected world, we should defend, cherish, and champion neutral legal principles and processes. And we should do so in practice, and not just on paper. Thank you very much.